Hello there. Welcome to video 174 from Sumit Academy. I do hope that you have subscribed to my channel. Do subscribe now so that you do not miss out on my previous or future videos. And do remember to like and share this video too. Do remember that the videos in my YouTube channel are for you to use for your examination purposes. They are free to use and will always remain free for you all. Do use the information in these videos to the best of your ability to succeed in your endeavor to join the civil services. To make your task a little easier, here is a complete list of all the 174 videos available on my YouTube channel. The list is divided into the playlists under which they are available. Do have a look. In this video, we shall study the Government of National Capital Territory of Delhi Amendment Act 2021, by which the constitutional and legal responsibilities of the Lieutenant Governor and the elected government have been clarified. It accords primacy to Delhi's Lieutenant Governor, LG, over the elected government. According to the legislation, the government in Delhi means the Lieutenant Governor. It amends the Government of National Capital Territory of Delhi Act of 1991 to give primacy to the centrally appointed Lieutenant Governor of Delhi and makes the elected Government of Delhi subsidiary. The elected government will now have to seek the opinion of the Lieutenant Governor for any executive action. The GNCTD Act of 1991 provides a framework for the functioning of the Legislative Assembly and the Government of the National Capital Territory, the NCT of Delhi. The Act amends certain powers and responsibilities of the Legislative Assembly and the Lieutenant Governor. The 2021 amendment provides that the term government referred to in any law made by the Legislative Assembly will imply the Lieutenant Governor, the LG only. The amendment allows the Legislative Assembly to make rules to regulate the procedure and conduct of business in the Assembly. In its July 2018 judgment, the Supreme Court had ruled that while the Lieutenant Governor must be informed about Delhi's cabinet decisions, his concurrence was not needed except in the case of police, public order, and land. This amendment, however, says that the opinion of the LG shall be obtained before taking any executive action on decisions by the Council of Ministers of the Delhi government. The Act grants the LG power entrusted to him under the proviso to Clause 4 of Article 239AA in selected cases. Now, Article 239AA of the Constitution of India deals with the special provisions for the National Capital Territory of Delhi. It makes it compulsory for the government in Delhi to obtain the opinion of the LG on all executive matters. In a later press release, the Union Home Ministry said that the Act would in no way alter the constitutional and legal responsibilities of the elected government to take necessary action on subjects that had been transferred to it, including health, education, agriculture, forest, and transport. The office of Delhi LG then issued a notification listing out the matters that needed to be cleared by the LG. Now, these include matters related to police, public order, land, services, and others not specified. Making of subordinate legislations, that is, rules, regulations, schemes, bylaws, and matters related to Delhi Finance Commission, constituted under the Delhi Finance Commission Act 1994. Three key matters of governance: public order, police, and land were already in the hands of central government before the Act came into force. The elected Delhi government only had control over matters such as health, education, agriculture, forest, and transport. The Act allows the Legislative Assembly to make rules to regulate the procedure and conduct of business in the Assembly. It provides that such rules must be consistent with the rules of procedure and conduct of business in the Lok Sabha. The Act prohibits the Legislative Assembly from making any rule to enable itself or its committees to either consider the matters of day-to-day administration of the NCT of Delhi and conduct any inquiry in relation to administrative decisions. Further, the Act provides that all such rules made before its enactment will be void. The Act requires the LG to reserve certain bills passed by the Legislative Assembly for the consideration of the President of India. Now, these bills are those which may diminish the powers of the High Court of Delhi, or which the President may direct to be reserved, or dealing with the salaries and allowances of the Speaker, Deputy Speaker, and members of the Assembly and ministers, or relating to official languages of the Assembly or the NCT of Delhi. The Act requires the LG to also reserve those bills for the President which incidentally cover any of the matters outside the purview of the powers of the Legislative Assembly. The Act specifies that all executive action by the government, whether taken on the advice of the ministers or otherwise, must be taken in the name of the LG. The Act adds that on certain matters, as specified by the LG, his opinion must be obtained before taking any executive action on the decisions of the minister or the Council of Ministers. However, the elected government of Delhi and a large group of civil servants are of the firm view that this move will not only paralyze governance in Delhi, much to the detriment of public interest, but also have grave repercussions on how federal governance is carried out in India. They feel that it deprives Delhi's citizens of the right to govern themselves in matters such as health, education, water, power, electric supply, and roads. There is no justification to concentrate all powers of governance in the union government merely because Delhi is the country's capital. The demand for full statehood for Delhi has been consistently championed by all political parties, even though it is a national capital territory that may necessitate differential treatment. Now, that led to the insertion of Article 239AA into the Constitution of India, establishing an elected legislature for Delhi. The opening lines of Article 239AA state that the Council of Ministers shall be collectively responsible to the Legislative Assembly. Interpreting the scope of this provision, the Honorable Supreme Court ruled that the Lieutenant Governor has not been entrusted with any independent decision-making power. He has to either act on the aid and advice of the Council of Ministers, or he is bound to implement the decision taken by the President on a reference being made by him. Now, this refers to para 277. However, the recently enacted GNCTD Amendment Act 2021 strikes at the root of these principles and renders null the democratic right of the citizens of Delhi, feels the elected government and the group of retired civil servants who wrote a letter regarding this under the aegis of Constitutional Conduct Group or CCG. The Centre has maintained that the Act is in line with the Supreme Court's July 2018 ruling on the ambit of powers of the Lieutenant Governor and the Delhi government. It said that the amendments would lead to transparency and clarity in governance in the NCT, the National Capital Territory of Delhi, and enhance public accountability. The Supreme Court has said that by no stretch of imagination Delhi can be accorded the status of a state under the present constitutional scheme. The Honorable Court said the LG was not like a governor of a state but an administrator in a limited sense, working with the designation of LG. It further observed that the Constitution was constructive and that there is no room for absolutism. There is no space for anarchy, said the Honorable Supreme Court. Well, that's all from me in this video. This video is based on the information freely available on the internet. No originality is claimed for the same. The intention of this video is only to prepare candidates for answering examination questions on the subject and not for any financial gains. Do like and share this video and do subscribe to my channel now so that you do not miss out on my previous or future videos. Till later then, cheerio.